Tatyana Davidoff. Tatyana is an equity partner at LINDEMANNLAW. With more than 30 years of working experience, Tatyana advises clients on regulatory matters, cross-border and compliance issues, and AML policies. Further, Tatyana advises in financial and capital markets law, fund law, M&A, real estate and relocation, as well as blockchain and technology law. Tatyana also sits on selected boards of directors.
Hello everyone, and let's demystify what escrow account is. Well, escrow account, as you can see on your slide, is a type of block account which is established and managed by the third party, normally a lawyer, for buyers and sellers in order to facilitate the deal. The function of a lawyer in this case is called escrow agent, and the funds which are on the account are of course separated from escrow agent's own funds. These are not the funds of the lawyer, they belong to buyer, to the seller, to the buyer. Well, why do we need an escrow account? Escrow agent plays an imperative role in facilitating and securing the transaction. Escrow agent is normally trusted by all parties, the bank, the buyer, and the seller. The parties who are involved in the transaction engage the third party, typically a lawyer, a law firm, under the escrow agreement to temporarily hold an escrow funds to provide certainty and confidence that all parties meet their obligations. Normally, escrow services demand and solve the issue who acts first, the buyer, the seller, are the funds revealed first, is the asset released first. These questions are solved by having an escrow account and escrow arrangement. Next slide, please. So, the role of escrow agent, the most important role of the escrow agent is impartiality. The synonyms, the keywords are here, neutrality and independence. The reason why the lawyers are usually the good fit to be an escrow agent. Lawyers are impartial, law firms are impartial, thus they are the best escrow agents. Second, the most important feature are infrastructure and expertise. So lawyers acting as escrow agents obviously have access to the banks and long-standing connections and professional ties with the banks. They are trusted by the banks, not only by the buyer and the seller. They know the regulatory framework, which is very important. This makes again and again escrow agent as a lawyer the best fit. And last but not the least, very important, compliance with legal regulations. It's vital important to emphasize escrow activity is a regulated activity. Thus, the best fit for an escrow agent is again lawyer or a law firm. Why? Because all the requirements of the due diligence, anti-money laundering and KYC are not in this case conducted by the bank, but are trusted to the escrow agent, which is normally the law firm. And this whole setup makes the whole deal more confidential. That's not the last thing for the buyer and seller. Normally, deal is a very confidential thing. Next slide, please. Well, how are the escrow accounts structured? There are three very important parties: the buyer, the seller, and the escrow agent. The banks normally play a role of a depository bank. Well, the depository is the seller, the one who places funds on the account. The beneficiary always will be the buyer, the one who eventually receives the assets, and the escrow agent. If we look at the structure of the escrow deal, then there are several very important points. First, the assets needs to be described, description of the assets. Next, the most important thing is deposit period, for how long you deposit your money on the escrow account in order the deal to take place. Release conditions is utmost important thing. Why? Because these are the modalities, the triggers under which the deal actually happens. And last but not the least, obligations of the escrow agent himself. Other things could be included like hedging modalities, etc., to facilitate the thing while it takes place. Next slide, please. So the takeaways from my part are the following. In order to choose the right escrow agent, in our case we recommend of course Swiss law firm, our firm, Why? The takeaways from me to you, following things, can't be underestimated. Legal expertise. Lawyers have thoroughly understanding of the underlying transactions. You don't accompany a deal which you don't know or understand. We do.
Just say something, Tatyana. I mean, we are working on both sides, right? I mean, we are working for the clients in such transactions, but we're also working impartially as an escrow agent. So, I mean, we know both roles. So that typically helps.
Yes, this will be, thank you, Alexander. This will be clear in one of the next examples. Thank you. So, impartiality is the role of the escrow agent himself, and trustworthiness. Okay, the lawyers are normally bound by high ethical standards and professional codes of conduct. That's more or less same in every country, that these codes need to be adhered to. Problem-solving skills. Many things can go, if not wrong, then just unexpectedly arise during the deal, while the deal is still ongoing, taking place. There can be some disputes. Again, the law firm is the best fit to solve the problem, to take, to accompany any negotiations, and during negotiations, which is very important, during the time where a deal is still ongoing, taking place, to find a solution. Normally, when deal is on, one has no time to interrupt, to go to court. Things should be solved. Any issues, any problems arising should be, ongoingly solved. And again, the law firm is the best fit. And also the law firm can provide comprehensive services. One of the things was mentioned already by Alexander. Escrow agent is always impartial, but you can have a lawyer on your side as a seller or the buyer. That's something else. We will talk about that later. And this also allows you to reduce the costs. You do not need to hire, again and again some consultants. All you need an escrow agent and possibly a lawyer on your side, which is a different entity, but that does not have any conflict in it. So these are my takeaways for the moment.
Thanks a million, Tatyana.